If you were recently arrested for domestic violence and you think that your case is different because the victim does not want to press charges, it is not. The system is designed to convict you and you don't even know it yet. You might think that if the victim recants, the case will go away. But the truth is, the prosecution and the judge do not care. They see this all the time. They are tired of victims recanting. Let me explain. In the 1980s, as little as 5% of domestic violence cases with injuries were prosecuted. But by 2010, that number had risen to 80%. Why? Because over the years, prosecutors stopped seeing domestic violence as a family issue and started treating it as a crime against the state. In jurisdictions with aggressive enforcement of domestic violence laws, 65 to 70% of victims do not cooperate with the prosecution. The victim is actively trying to stop the prosecution, just like in your case. One prosecutor quoted in an article put it bluntly,
"I would have no problem putting a victim in jail because she refused to cooperate. I have a legal obligation to the people of this state to prosecute crimes of this nature. To me, these are serious offenses that affect other people in the community."
If you think that the alleged victim controls the case, you are already losing. Once you are arrested and you are in their system, they will move forward whether the victim wants them to or not. I'm going to be explaining exactly what that looks like. My name is Veronica. I'm a domestic violence criminal defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. So let's jump right in. Let me show you exactly how the system is designed to prosecute you, even when the victim is 100% on your side. We're going to be going through a case study based on what happens in real life every single day. Meet Jason. Jason was arrested for domestic violence after an argument with his girlfriend Emily got out of hand. Emily called 911 in the heat of the moment, but by the time that Jason was charged, she regretted it. She didn't want him prosecuted. In fact, she told the district attorney that she didn't want to testify. She even recanted. She was a little bit afraid of getting in trouble herself, but she told him that she exaggerated in her original statement. Here's how the prosecution can force a conviction anyway. Step 1. The first thing that the prosecution does is they subpoena Emily, so she has to come to court, otherwise a warrant could be put out for her arrest. She comes to court, and the first thing that the prosecution does at trial is they put her on the stand and then tear her apart. Here's how it goes.
Miss Smith, when you spoke to the police, you said that he grabbed you hard, didn't you?
I was upset.
You also said that you were scared. That's what you said, right?
I didn't mean it like that.
But you did say it.
Yes.
And you said that Jason hurt you.
I was emotional.
And now months later, you're saying that none of that happened?
That's right, because it didn't.
You and Jason are still together, correct?
Yes.
You don't want him to go to jail.
No.
But that night, when no one was telling you what to say, you told the truth.
I overreacted.
Look, the prosecution's goal is to make the jury believe that Emily is lying now, not that she lied before. If the victim recants, the prosecution argues that she's covering for the defendant. And everything that I just described, it's not a theory. This is how it actually plays out in real courtrooms. It's not just the prosecution. The judge can sometimes make it very hard for the victim to take back what they said initially and be believed. Here's a real life example from a real court transcript. I can give this real life example because it's not one of my cases, of how a judge treated a recanting victim.
So let me see if I've got this straight. We're here trying this case because you're a liar? Is that correct?
I was upset.
Answer the question.
I lied about some of these things.
A lot of victims in that situation end up folding. Even if they don't, though, the jury can see that the judge is pressuring the victim and that the judge doesn't believe the victim, that they made it all up or they exaggerated. I've dealt with this issue many times in court, and I did notice in that transcript that the defense attorney isn't objecting. I mean, personally, I would be jumping out of my seat because I think that the judge was way out of line, but this is a theme throughout domestic violence cases. If you don't act early and you don't have a strong defense, you can easily lose, especially if you underestimate how serious it is because the victim's on your side. Step 2, the prosecution brings in an intimate partner violence expert witness, and this is specifically allowed in California, to explain why the victim is supposedly lying for her abuser. The intimate partner violence expert witness testifies,
"Victims of domestic violence often take back their statements, but that doesn't
expert witness
mean the abuse didn't happen. Research shows that they may recant because they fear retaliation, feel guilty, or want to protect their partner from legal consequences. So when a victim says, "I made it up," or exaggerated my initial report, it's not because she was lying before. It's because she's under pressure now.
Now, one thing you might notice in the expert's testimony, and this is common, is that out of all those reasons why someone might say, "I exaggerated before," or "I lied before," or "I was the aggressor before," and then in court say, "I made it all up," it might be because they really did make it all up, or they really did exaggerate, or they really were the aggressor and now they're coming clean. Using experts like this is just another way that the prosecution ignores the victim's wishes, tries to make the victim look crazy or weak in some way, and still pushes the case forward. If she sticks to her original statement, they say that she was telling the truth before and now she's lying. Either way, this is another witness, a so-called expert, pitted against the defendant. Now let's hear another quote from a real prosecutor describing their thought process when a victim recants.
Although with my training and experience, I can imagine why a victim would be reluctant to testify against her abuser, I can never be totally sure of the underlying reasons. Is the victim declining to cooperate to ensure her own safety? Is it due to continuing feelings of love and loyalty? Is it to maintain financial security? Is she being pressured or threatened by her abuser or family members? Could the reason be something less noble?
That's a quote, again, from a real prosecutor. How about something more noble? How about having a conscience and deciding to come clean? Maybe they were afraid of getting arrested themselves in the moment. Maybe they were drunk and angry at you and didn't think about the consequences. And maybe they even thought that they could drop it later and this would just kind of teach you a lesson. And now they're like, oh, crap, I need to come clean. I can't have, this person convicted whether I'm with them or not because of my lie. But prosecutors do not think of it like that. And so they keep fighting to make sure that the case moves forward. Just as an aside, in my opinion, and I think in the opinions of many people that have been in the position of being a victim in a domestic violence case where they do want the charges dropped, this attempt to help women escape abuse and the refusal to listen to them is infantilizing and frankly offensive. While a lot of these so-called experts and prosecutors consider themselves feminists, this, along with the idea that we should believe all women, is based on this premise that women are innocent, childlike, perfect angels, and it's not true. That is not reality. And part of the reason that I focus my entire practice on domestic violence is because I want to fight against this idea that women, in particular, need the state's so-called protection even when they don't want it. Women should have autonomy, just like men. Step 3. Next, the prosecution plays a 911 call to make the jury believe that the first thing that the victim said is the truth, no matter what she says now.
911, what's your emergency?
I need help.
Go ahead.
My boyfriend Jason, he grabs my arm and he wouldn't let go. He left. I don't know where he went, but I don't feel safe.
The district attorney is going to use that 911 call to argue that her first reaction and what we heard on that 911 call is the real truth. The jury's heard her sounding scared, upset, and talking about Jason grabbing her arm. The victim sitting up there on the stand alone, being cross-examined by a lawyer, the prosecutor, is going to probably have a difficult time trying to explain that maybe on that 911 call, she was upset for a different reason, or maybe she exaggerated and why. That is exactly the prosecution's goal. Step number 4, they push for a conviction no matter what. This is how the system works. Once you are arrested, the prosecution's only goal is to convict you, even if the alleged victim is on your side. At trial, the prosecutor, in his closing argument, says,
Ladies and gentlemen, this case is simple. The victim called 911, gave a detailed account to the police, and now, months later, she's changing her story. We know why this happens. Victims protect their abusers, but the evidence doesn't change. You heard her voice on the 911 call. You heard from the expert who explained why victims recant. This is how the cycle of abuse continues. Today, you can stop it. Find the defendant guilty.
So look, you cannot rely on the alleged victim dropping the charges or not cooperating and not working out because the decision is out of their hands and the prosecution knows how to deal with this. This is nothing new to them. I know it might be new to you, but to the prosecution and prosecutors who only prosecute domestic violence cases, just like I only defend against them, they know exactly what to do in this situation. Prosecution's attitude toward the defendant and to the victim is don't even bother recanting. This is the prosecution's case. This is our case, not yours. I once had a trial where the prosecution really wanted to put my client in jail, even though the victim adamantly recanted. Again, she was completely on our side. The DA's office, this is just an example of how they treat alleged victims. They treated the neighbors who were testifying against my client and really against the alleged victim like royalty. They're paying for their Ubers, making sure that they had bottles of water. So the alleged victim is getting kind of annoyed, and she's like, can I get an Uber too? Because she's driving to the courthouse every day, paying for her parking. They straight up told her no. Why? Because they are not on her side. We won, by the way. But again, it was not an easy battle. And without understanding how all of this works, even with her completely on his side, they could have easily lost. He easily could have been convicted. By the time that you step into the courtroom, the case against you is already being built. These are professional lawyers who do this every single day. Who know that more than half of victims recant, want nothing to do with it, don't want you prosecuted, don't want to come to court. They do not care, and they know how to deal with it. The only question is, are you prepared to fight it? If you think you have time to wait and see what happens, you are making a huge mistake. You know, right before I started filming this video, so 20 minutes ago or so, someone called my office, and he had called our office about 3 months before, and he had not been to court yet for his first court date. He said, you know what, I'm just going to wait and see what happens at my first court date, right? Okay, I mean, I don't think that that's a good idea, but I respect it, and I know it's expensive to hire a lawyer. Sure, you just bonded out of jail. Okay. Well, it turns out, and I'll keep this very anonymous here, but he's found himself in a terrible situation now. He has a felony conviction, and he's calling to see, what can I do about it? Maybe I can do something, but I can tell you it's going to be a lot more difficult and a lot more expensive than it would have been 3 months ago to get this done. At this point, another attorney has been handling it. It's been screwed up. Actually, Louisa, who works at my office, mentioned, you know, this kind of outcome that this person got. None of our clients ever get this outcome. We always get something way better. I mean, this is crazy. And it's true. I've gotten cases dropped before court by fighting aggressively very early on, basically trying the case before the prosecution has locked their case against my clients. When charges get filed, there is a lot that can be done, but not every attorney is going to do it all. Not every attorney has time for it. Not every attorney is as good as another. Whatever you do for a living, you know, some people are good at it, some people care about it, and some people are not. I've also taken these cases to trial and won, whether the alleged victim was completely on my client's side, completely against my client, or somewhere in the middle. The biggest mistake that you can make is waiting. Most of my clients do not end up with a conviction, but only because they did not wait to get help and because I fight really hard for them. I don't give up. I try everything possible to try to get the case dropped and avoid a conviction. But if you take this approach of sitting back, hoping for the best, trusting the universe, you are playing right into the prosecution's hands. So what you need to do right now is do not make any statements to the police or prosecution. Don't call them up giving your side of the story. Don't answer calls from detectives. Don't encourage, although you can't stop the victim from calling the police or detective or whatever, don't encourage the victim to do so. That can often make it worse. Anything you say can and will be used against you, and anything that the victim says can and will be used against you, even if they are calling and saying that they made it up. Get an attorney immediately. Hopefully when you're watching this, it is before your first court date. If not, don't take a deal thinking that you're going to clean it up later. Make sure that you get help and that you get the best possible outcome that you can. If you do have a criminal case in California, feel free to book a consultation. You can find my number down below. You can also click on the link and book directly there. And I hope you found this video helpful. If you did find it helpful, don't forget to like, subscribe, ring the bell. And if you have a question or comment, leave it in the comments.